So, Mr. Valentine, would you unmute, join us, or if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay. And is that how you'd like me to refer to you?
Yes, ma'am.
Okay. I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about. Is we're still pending trial. And you weren't, the pretrial services violation, that's right. You've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today. And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th, and within a month we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions.
Right away. This hearing isn't about whether Mr. Valentine is guilty of DUI. It's about whether he followed the court's release conditions while waiting for trial. That's a huge distinction. Judges take pretrial violations seriously because they're deciding one thing. Can this defendant be trusted outside custody? So here's the question for you. Should one failed release period automatically justify a higher bond? Or should the court give another chance?
Release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
Oh, Mr. Valentine?
So I object to state motion. The release conditions that were set were not returned. Ooh.
I can hear you.
Okay. Yeah, the release conditions that were set were not returned to its original state. The release conditions were only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything.
We got everything.
For tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? Or I'm sorry, American National Valentine.
Now the defense is shifting the focus away from the failed drug tests and toward the fairness of the release conditions themselves. It's an interesting strategy because instead of denying the court's concerns, he's arguing the rules shouldn't have applied after certain charges were dismissed. But notice what the judge is doing. She keeps steering the conversation back to the current case and the facts directly in front of her.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. It's my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
even my bail,
one,
they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
so this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay,
Yes, I have.
so, all right, so you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge.
This is the turning point of the hearing. The judge has listened to both sides, reviewed the court history, and now she's weighing compliance over technical arguments. In bail hearings, past behavior often speaks louder than promises. Do you think the judge is focusing on public safety, or is she being too strict? Let me know what your take is.
If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set, release conditions for that charge, that should be done on that case. But they're two separate cases now.
All right.
Does that make sense?
Yep, it does. And there was, all right. I guess I don't agree with you. There was a request to October 28th to change the release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount because $5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a $10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that $10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing I'm gonna set this I'm just gonna set everything for that January 14 day. And so that we've got everything together.
And there it is. The bond doubles from $5,000 to $10,000. From the court's perspective, the previous conditions weren't working, so increasing bail becomes a way to encourage compliance before trial. Whether you agree with that reasoning or not, this is one of the biggest moments in a hearing, because it immediately changes the defendant's options moving forward.
What time that is, but you either, as I said, it's $10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. But we'll set this hearing. The next hearing will be January 14th at 2:30. So pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending in the third degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it
Nature of
under
the cause.
admiralty jurisdiction or common law jurisdiction?
Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a
That's what I'm
common
telling
law?
you.
Is
No,
it under
it's
common law
RCW
or admiralty?
4661. It's under Washington
So-
state law.
Don't you have the duty to make the nature and cause clear to me, ma'am?
I
Do I
have.
not have a right to know the nature of the cause?
Yeah,
nature and
and I
cause?
have. And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I requested
That's what I've
a
told
bill
you
of
today.
particulars. I've requested a bill of particulars, and I've requested the case transcript, and I've gotten neither.
yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct
If
jurisdiction.
these questions sound familiar, there's a reason. Arguments about common law, admiralty jurisdiction, and demanding the court explain its authority are frequently associated with sovereign citizen-style courtroom tactics. Courts almost always reject these arguments because criminal jurisdiction is established by state law, not by the defendant's preferred legal theory. The judge is trying to answer without letting the hearing spiral into an endless debate.
Correct jurisdiction. You're in
I said
Thurston
a
County
case.
District Court.
I said I asked for a case transcript and a bill of case transcript and a bill of particulars, and I still haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars, and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right,
Still haven't
so,
made clear the nature and cause of the charges, ma'am.
all right, well, I think I have. So you're to turn yourself in to Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have
I'm
an
just asking
obligation
you
to be.
I'm just asking you
I
as
understand.
my
I've
right. Is it
answered.
not my right to know the nature and cause of the charges?
Yep. I've answered you,
so-
Mr.
so
Valentine.
which one-
I'm not going to go in circles. You're in custody by Friday. You're post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
And it was a void ruling. It's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not going to honor your oath to
We're
uphold
done,
the
Mr.
Constitution.
Valentine. I'm honoring my oath, and I've done exactly what I'm to do by state law and Constitution.
You haven't made
simply
clear the
disagree.
nature. You haven't
We're
made
done,
clear the
Mr.
nature and cause of
Valentine.
the charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr.
The
Valentine.
hearing ends exactly where many of these courtroom exchanges do, with the judge enforcing her ruling and refusing to revisit issues she's already decided. Once a judge has ruled, repeating the same arguments rarely changes the outcome. Instead, the proper path is usually through motions or appeal, not continued courtroom debate. What do you think about the judge's handling of this hearing? Was she patient and fair, or should she have spent more time addressing Mr. Valentine's concerns? Let us know your thoughts below.